Thank you for letting us speak today. We're here today because we'd like to discuss a matter that strikes at the very heart of our justice system, the equal application of our laws designed to protect vulnerable adults. Senate Bill 113, which amends the Michigan Penal Code regarding financial exploitation of vulnerable adults, represents an important step in strengthening protections, but laws are only meaningful when they are applied to everyone, regardless of their title, profession, and connections. The tragic case of my father-in-law in Oakland County, the estate of John White, illustrates this reality all too clearly. Mr. White, an elderly gentleman with an estate valued at over $1.8 million, needed protection. Instead, his estate became vulnerable to exploitation through a system that failed him at multiple levels. While one family member, David White, has been convicted of conducting a criminal enterprise and is now serving prison time, the family has raised serious questions about why others involved in the probate process, like attorneys and court staff who help facilitate or worse, failed to prevent exploitation, face no similar accountability under MCL 600-1701C. Senate Bill 113 specifically addresses fraud, deceit, misrepresentation, coercion, and unjust enrichment used to obtain a vulnerable adult's money or property. It creates increased penalties based on the value taken that continues to apply even after the vulnerable adult has died. Senate Bill 113 smartly acknowledges the true nature of elder exploitation by allowing authorities to combine smaller thefts over time into their full amount, understanding that predators often drain resources bit by bit, hoping no one notices the pattern until it's too late. But these protections are meaningless if we do not apply them equally to everyone who interacts with vulnerable adults, including and especially those in positions of trust and authority. The legal profession, while vital to our society, cannot become a shield against accountability. When attorneys draft ex parte orders that redirect assets, when they assess fees that seem disappropriate to services rendered, or when they fail to act as proper fiduciaries, they must be subject to the same scrutiny and potential consequences as any other person who exploits a vulnerable adult. Our system currently created a dangerous imbalance. Family members who reported suspected exploitation by legal professionals often found themselves without recourse, ignored by law enforcement, or most troubling, facing retaliation for questioning powerful figures within the system. This is not justice. This is not equal protection under the law. The penalties outlined in Senate Bill 113 are significant as they reflect the seriousness with which we view exploitation of our vulnerable citizens. But these consequences must be applied based on actions on all parties who committed them, and legal professionals must not be shielded from doing the hard time too. The law states plainly, a person shall not, through fraud, deceit, misrepresentation, coercion, or unjust enrichment, obtain or use a vulnerable adult's money or property. Nowhere in this language do I find a clause that says, except for attorneys and judges or court officials. The prohibition applies to everyone. The law makes no distinction between exploitation by a stranger on the street or somebody wearing a suit in a courthouse. What happened to John White and to so many other vulnerable seniors across our states demand that we hold everyone accountable to the same standard of justice. When the White family sought help, they weren't asking for special treatment. They were simply expecting that everyone involved in their family's exploitation would answer for their actions, whether they wore a suit to court or sat behind the bench.
Thank you for your testimony.
It's my last paragraph, please. As we strengthen our laws protecting vulnerable adults, let us also commit to their equal application. Justice demands nothing less than accountability for all who would exploit our most vulnerable citizens, be they family members, caregivers, or those entrusted with upholding the very laws designed to protect. Thank you.
Mr. White?
Ladies and gentlemen, thank you for allowing me to speak today. I'll try to be brief and concise about a matter of profound importance to our community and the legal system. The recently enacted Elder and Vulnerable Adult Personal Protective Order legislation represents a critical step forward in safeguarding our most vulnerable citizens. However, a law is only as strong as equal application of all members of society, regardless of their professional status, connections, or position of authority. The case of my father, John White, illustrates a devastating failure in our system. Here was an elderly man whose estate exceeded $1.8 million, yet instead of being protected by the key the very institutions designed to serve him, his assets became prey to those entrusted with their case, attorneys and officers of the court. When family members sought protection and intervention, they encountered roadblocks at every turn. Our attempts to use existing legal remedies were thwarted. Our pleas to law enforcement and county commissioners fell on deaf ears. This is not what our legal system should represent. The fundamental principle underlying our country's values is that no one, absolutely no one, is above the law. A bar license is not a shield against accountability, but rather should represent a higher standard of ethical conduct. When attorneys and judges violate the trust placed in them, the damage extends beyond the immediate victims. It erodes public confidence in our entire justice system. We cannot have a two-tiered system where ordinary citizens face one standard of justice while members of the legal profession have immunity from very laws they're sworn to uphold. Financial exploitation is equally harmful, whether perpetrated by a family caregiver or by someone with legal credentials. The new protection order legislation must be applied with equal force to everyone. Court officers, attorneys, judges, all must be subject to the same scrutiny and consequences when evidence suggests exploitation. The law specifically addresses fraud, deceit, misrepresentation, coercion, and unjust enrichment, and improper leveraging of relationships for financial gain. These provisions must apply in the courtrooms and law offices, just as they do in the homes and care facilities. Let us ensure that this protection intended by the law extends to all vulnerable adults, especially when those who might exploit them hide behind professional credentials. Only then will we truly honor the purpose of legislation and the principles of justice it seeks to uphold. And just one last thought.
Thank you both for your testimony. Are there any questions?
Attorneys can be criminals also, just like in any profession, like my profession.
Are there any questions?
Thank you.
Thank you.
Okay, thank you so much. Senator Santana has a question.
Okay. On the attorneys that can be criminals, because what they do is they do leverage the positions in the courtroom. And in my case, I witnessed it in Oakland County probate court for 12 years. I mean, I was in there for 12 years and witnessed how they don't do, their accounting. They deny justice by I went through the whole process, went to a court of appeals, and there was a judge here 2 weeks ago that I really honor. His name was Brock Schwartz, I believe his name was. He gave me a favorable court of appeals decision and told Judge O'Brien in Oakland County Court, hey, you need to have this court of appeals. You have to have a jury trial. He remanded it back to their court. And the judge thwarted it. He just said, no, we're not going to do it. One day before the jury, he had scheduled the jury trial, and one day before that, he calls an ex parte meeting and says, hey, we're deciding something different here between the court officers and the judges. And I am on, they're objecting to it. They say I didn't appeal that, but why would you appeal a court of appeals once again after $17,000? You spend $17,000.
Thank you. Sorry, we need to keep moving because we have a number of speakers. Okay, so Senator Johnson?
Yes, thank you. I think part of the things you're talking to is our Attorney Grievance Commission. When somebody sends in the grievance, it's secret, no one else knows. And our Judicial Tenure Commission, less than 10% ever come before them. And then our guardians, that they are called professional, are not licensed to complain in any way. Michigan is actually ranked the last state in the nation for transparency for our system. So thank you so much for speaking today.
Thank you.